Judge, my name is Paul Lipton. I am here on behalf of the Standing Committee on Professionalism of the Florida Bar. We are engaged in a program of interviewing people of the Florida Bar, judges and lawyers that have made what we believe, a substantial positive difference both in the profession and in society in general. And we're here today to spend some time with you, so thanks for joining us.
Delighted to be here. I can't imagine why I got on your list.
Well, a lot of people think you should be.
Thank you.
Judge, I'd like to start out with you giving us a little oral history of Peter Fay, college, law school, and some background.
Certainly. I was raised in Fort Lauderdale, Florida, when it was a very small town. Attended the public schools there. I loved athletics, participated in almost every sport that I could get involved in, and was fortunate enough to be offered several athletic scholarships by some universities and colleges around the country. I ended up at a very small school in Winter Park, Florida, Rollins College. Played football, basketball, and rode crew there. And then, of course, went in the United States Air Force immediately after graduation. Our country was engaged in the Korean situation, and all of us were going in the service, so I joined the Air Force and went to Lackland Air Force Base for basic training, and then was fortunate enough to get into OCS. Wanted to get into flight training, but shortly after we started, they decided they had too many pilots, so they washed us all out. And I became a personnel officer and was sent from Craig Air Force Base, which was a pilot training base, to the Azores. And turned out to be a real blessing in disguise, because in the Azores they had no lawyers. And as you know, in the military service, if there are no lawyers on a base, why, they simply appoint officers to be both the prosecutor and the defense counsel. The only requirement being that the prosecutor can't be any better qualified than the defense counsel. And of course, since none of us were qualified to do anything we were doing, that was easy. And I was the defense attorney on Lodges Air Force Base for the better part of a year, and was engaged in trying lawsuits and was just fascinated with the whole process. So I couldn't wait to get to law school. Went to law school on the GI Bill of Rights at the University of Florida. Came back to South Florida to practice law.
Well, when was that? What year was that?
In January of 1956. And was offered a job by a very small, wonderful firm, Stewart Patton and Sam Canner, Patton and Canner. They knew that I wanted to get in, or at least attempt to get into trial work. And through Stu Patton's friendship with Perry Nichols and Billy Gaither and some others there, I was sent over there. I have to tell you, the short version of a wonderful story is the Nichols Firm offered me a job, and I was really too embarrassed to take it because I was with Patton and Canner, and they had paid my way to take the Florida bar exam, and they had done a lot of wonderful things. And Mr. Patton played golf with Billy Gaither, and apparently Gaither told Patton about my turning him down, and Mr. Patton called me in and fired me the next Monday morning, and that's how I went with the Nichols Firm. And it was a marvelous experience, and I practiced with Nichols, Gaither, Green, Frates, and Beckham from 1956 through 1961, when Bill Frates and I started our own firm, which became Frates, Fay, Floyd, and Pearson. And I was with that firm until I went on the district court in 1970. I was appointed by President Nixon to the United States District Court for the Southern District of Florida. And then in 1976, went on the U.S. Court of Appeals for the old Fifth Circuit. And as you know, that court was divided by Congress into the new Fifth and the new 11th. And we are now headquartered in Atlanta and are called the 11th Circuit, U.S. Court of Appeals.
So you were a trial attorney from, at least with the Frates firm.
Yes, from 1956 through 1970. As a matter of fact, my baptism into trial work was something I doubt any other young lawyer would ever have the opportunity to engage in. It's fortunate that I was single. When I was assigned to Bill Frates, and Bill Frates was as fine a trial lawyer as we've ever had in this area. Bill and I tried 32 cases to jury verdict the first year I was with him, and 33 cases to jury verdict the second year I was with him. Now, there are lawyers that practice for 40 or 50 years and never have that much trial experience.
That's an amazing number. At that time, 56 through 70, was your work mainly in state court or state and federal court?
Well, I would say most of our trials were in state court, although we did a lot of federal practice. We did a lot of maritime work, and those cases would end up in federal court. We did a lot of federal employers' liability cases, railroad workers' cases. We also had a large number of diversity cases that would end up in federal court. So we did both, although, as you know, there weren't very many federal judges when I started practicing law. I think Judge Emmett Choate was the only full-time federal judge in this area, and then Judge Joe Lee came over and was assigned here, and we had two. So even though the numbers were small in all the courts, I think we either had 7 or 9 state circuit judges when I started practicing. There were a lot more in state court than there were in federal court. Of course, the numbers were smaller and the bar was smaller.
What was it about being a trial lawyer that ignited you?
I'm not exactly sure, although I've always felt that anyone who engaged in athletics would probably enjoy the sense of being an advocate and all that went into it. I think if we looked around the trial bar, even in different areas of the country today, you would probably find that an awful lot of the trial lawyers have been engaged in athletics, some form of competition as they were growing up. I'm sure that my experience in the Azores had something to do with my wanting to get back into trial work, particularly after finding out what I was supposed to do, having started out not having any idea what I was about or what the trial process was. Although, as you know, we had one manual in the service, so I read that book at least half a dozen times from cover to cover, and that was it. We didn't need a law library for research.
What was it like in 56, 60, those areas in the practice of law in Miami?
Well, I think Miami had a wonderful trial bar because we tried a lot of cases. There was an awful lot of trial work going on in this area, even back then. And the trial bar was small in number. You would see the same lawyers over and over and over. Even in the large firms, Blackwell, Walker and Gray was a huge firm by those standards. But their trial lawyers were, 4 or 5. The Sam Powers, Willis Flick, Jack Hale. So we saw them over and over and over again, and it didn't matter whether it was a personal injury automobile accident or a malpractice case. Now, when Bill and I started our firm, we did a lot of trial work in different areas. We did a lot of libel slander work. We started defending people like Time Life publications. I represented several insurance companies, so we started doing defense work. We started doing a good bit of contractual litigation. We got involved in the early days in arbitration. We ended up doing some things for various governmental bodies. Bob Floyd somehow got us involved in being city attorney for the city of North Miami Beach. Now, that was a real experience for a young lawyer who'd done nothing but trial lawsuits. But we branched out and got into those areas. But even then, the numbers were very, very small. The lawyers who were doing the actual trial work in the courthouse were were very limited. There were probably less than 100 who did 99% of the trial work.
I want to get back to that in a second.
Sure.
Let me ask you a more general question, though.
Mm-hmm.
Over the years, have you had a particular philosophy of life that has helped you maintain your balance during highs and lows?
Well, I'm not so sure. I tell people my life has been a series of accidents, and it really has. Now, maybe most our lives take us down a road that we couldn't really plan for or anticipate. I've always felt like I was very, very blessed by being at the right place at the right time, and an awful lot of life, I think, has to do with just pure luck or happenstance. But I had two wonderful parents. My mother and father were absolutely incredible people in this sense. They had survived the Depression. They were wiped out in the Depression, but their values were so solid, and they both impressed upon their children the benefits of hard work. Both my brother and I loved athletics, and as I told you, we played everything. But my mother made it very clear to us that if we ever made anything below an A or a B, we weren't going to play athletics. So the academic side was also stressed. My mother had been a professional librarian. So we talked about books, and we read books. My father was a businessman. He sold insurance. But he lived the Christian way of life. We didn't sit around and talk about it a lot, but it was just obvious from the way he dealt with people and his whole approach to life. And if my mother and father could ever do anything for anybody, they did it. They just thought that was the way you were supposed to live your life. So I'm sure a lot of that came through to us. And in turn, I feel like an awful lot of people have done a lot of wonderful things for Pete Fay. Favors that I could never repay. But I think in that sense, you try to do things for other people because you realize so many people have done so many wonderful things for you. I always felt very blessed that I got through college on an athletic scholarship. I felt very blessed that I was able to get through law school on the GI Bill of Rights. Those were just marvelous gifts that were made available to me, not because I had done anything right or anything outstanding, but it was just, and obviously those things changed the course that your life is going to take. I don't know many lawyers that could be paired with somebody like Bill Frates and spend 5 years learning how to practice law, learning how to try a lawsuit, learning what was right, what was wrong. There just aren't many mentors around like that. And he was not only a boss, he became like an older brother, he became like a second father. We were that close. We lived together for 12, 14 hours, 15 hours every day. So, and I think that sort of dictates what happens to you. And as I say, I've always felt very fortunate that I had those kinds of opportunities. I don't think you can plan for that.
Over the years, have you seen, well, let me ask you this. Do you believe that there is a difference between ethics and professionalism in our area of practice?
Well, I'm sure some academicians would say so, yes. They would say that you could probably be professional and you could talk about certain things that would be done or not done consistent with being a professional, and they might separate ethics. I don't think I would. It seems to me that it's all sort of wound together, if you will, in the same ball of wax or in our profession. I don't think one could be unethical and be professional and be a lawyer. So I think that the two go hand in hand, at least they do in my mind.
Over the years, have you seen a change in the practice of law in our community, whether it be for better or worse? Well,
I think there have been a lot of changes in the practice of law. a lot of changes. Some are good, some are bad.
Can I have some examples of your thoughts on that?
Well, certainly. I think computerized legal research is a marvelous improvement in the practice of law. The hours and hours that were wasted by each and every lawyer repeating everything that had been done by each and every lawyer before him or her, I think was nonsense. And I think the way we've speeded up that process and made it all available is truly wonderful. We used to cut and paste opinions. Now, of course, we can move paragraphs, we can move pages, we can make changes and reprint in seconds. All of those are marvelous, marvelous tools that are available to us. The downside, I think, has come with numbers. I think in a large sense, we have so many lawyers that we don't know one another, and I think there are real disadvantages to that. We could talk about the American Inn of Court program. We could talk about the English system. We could talk about the history of our profession. Numbers make it very difficult to continue to practice law the way you can when the numbers are smaller. When I started practicing law, we didn't need letters to confirm agreements. All you had to do was call up another lawyer. You worked out whatever the problem was, whether it was rescheduling a deposition or rescheduling a hearing. And it was much easier. I don't think it's as easy to practice law today. Now, I don't know whether that's good or bad. It's just different. I think the concept of billable hours, and I recognize the need to do it. Certainly if you have a large law firm with an enormous overhead, you have to have controls, and you have to know what people are doing. And they have to have some way of computing all of that. But I think the pressure that's been put on lawyers by billing on an hourly basis and having machines that literally charge clients every time they pick up the phone, they can't make a phone call without putting in a file number, has not been entirely good. I think it has changed the mentality of the practice. And I do think to some extent, and I don't know to what extent, but to some extent I think maybe lawyers are doing things that aren't absolutely necessary. I think they may even in some cases be doing things that they know are not necessary, but they feel obligated to do them for different reasons. And I don't think that's good. I don't think that's good.
Let's talk about some of these things. The numbers.
Sure.
A lot of people have said that because of the numbers, there's an anonymity that takes place. Any solutions, any thoughts you have on how we deal with that? Do bar associations help, or involvement? Do law schools have some participation in this?
Oh, yeah. I think every facet of the legal profession has to participate, and I think talking about it is probably the best approach, at least the initial approach that we can take, because very often you can solve these problems by simply talking about it. If you're thinking about methods or things that could be done, I will tell you that I have been very surprised that we don't have an internship in the legal profession. I thought 30 years ago that by this time we would have a very well-established internship. I think it's almost tragic that anyone who graduates from any law school with any ranking would think that they are capable of going out and practicing law. I mean, that's a nightmare to me that anyone would think they could do that, and of course a lot of people do. I think the first 3, 4, 5 years of anyone's practice are critical in the habits that are developed. They learn the approach to the profession. They learn how to become a professional in the true sense of the word. I don't think law schools can teach that. They can give them a foundation. They can attempt to train people to think like lawyers. They can teach us how to do legal research. They can teach us how to do legal writing. They can give us a basic concept of principles in certain areas, principles of law in certain areas, but they can't teach a student how to practice law. I think that comes by doing it. Maybe it's not a good analogy, but you don't learn how to ride a bicycle by reading a book. You've got to get on the bicycle and pedal and learn how to maintain your balance. Now, once you learn how to do that, I think you could ride any bicycle. I think any good trial lawyer could try any lawsuit. I don't think it matters whether it's a personal injury case or a malpractice case or a contract dispute. I don't think it really matters whether it's a civil case or a criminal case. There are different rules, there are different basics, but I think if someone learns how to approach a case, learns how to try a case, I think that individual can try any case and try it well, because they will know the areas where they need to go out and get help. They will know how to call in the experts. They will know where their strengths are, where their weaknesses are, and they'll put it all together.
You were fortunate enough, as you said earlier, to have Bill Frates, among others, as mentors for you. What are your thoughts about some type of mentoring program now, and how could we accomplish that? Any ideas, George?
Well, again, the numbers are going to make it very difficult, but I think we have to have it. I think that's what the American Inns of Court are all about. And we need more programs. I don't have any doubt in my mind that you could get thousands of AV lawyers around this country to voluntarily take on a younger lawyer, whether that individual man or woman was in his or her law firm. I think those lawyers would be delighted to act as mentors and to work with younger lawyers. Why we don't have it, I don't know. I really don't know the answer to that. I think it's a real shortcoming in our profession that we don't have some sort of a mentoring program or some sort of an internship.
You are involved in the Inns of Court.
Yes.
And can we expand those to include law students and young lawyers even more than it is today?
Yes, certainly we can. There's no limit. The idea is that you establish an inn and that any particular inn has a very limited number. But it's a limited number with a mix. You have a balanced mix of judges, of more experienced lawyers, of middle experienced lawyers, brand new lawyers, and law students. And I think the concept is wonderful. Now, there's an awful lot of economic pressure that gets involved there. It's very difficult for active practitioners to take 1 or 2 evenings every month and to work with other people and to get involved. But yes, I think we could do it. And again, I think it's one of those things we have to talk about, and we have to encourage people to do it. And we have to recognize people who do it. It's like pro bono work. I think we've gotten to the point where we've made pro bono work something that people are proud of. Law firms are stressing it. If the law firms stress it, and if young lawyers are recognized for the civic duty they are performing when they do pro bono work will take on a totally different air. It will have a totally different place in our profession. And this is what we have to do with these other programs. They have to not only become acceptable, they have to become something that people can take great pride in, because it is part of being a lawyer. We took the common law from England, but we also took a lot of other things from England when we set up our profession in this country. And as you know, the Inns of Court were treasured and are treasured to this day in England. And being a lawyer has to be something very, very special. And I think we need to do everything we can to keep it special. And it doesn't really matter whether we have 2,000 lawyers in Dade County or 10,000 lawyers. It still ought to be something very special, very unique. And it's up to judges and lawyers to keep reminding ourselves how totally unique we are and how totally wonderful it is as a profession. I mean, we are truly blessed to be involved in the legal profession. And when you think about it, we are so fortunate. We have received the best education our country has to offer. You have to have graduated from an accredited college, 4-year college, to get into law school. It's extremely difficult. The competition is very tough on an intellectual level. I think any accredited law school in our country is teaching on a very high level. So when you think about it, all of our lawyers have been given that gift, have been given that privilege. Most states, if not all states, now have bar exams, so we're tested on what we've learned. And when you think about it, it is an incredibly wonderful gift and privilege that we have been given. We ought to remind each other of that. And we ought to remind each other of the fact that as lawyers, we should be different. We want to be different. We want to be very, very different.
The sense I have from listening to you, which is a joy for me, is a great sense of gratitude that you have for what's happened to you in your life.
Well, I do. As I told you earlier, I just feel like so many people have done so many wonderful things for me, and I have been so fortunate. I was well aware my parents couldn't have paid a college tuition, but my mother made me well aware of the gift that I was being given when I was allowed to go to college. The thought that somebody would let me play the games that I love to play, and at the same time give me an education, a college education, in return for that was almost mind-boggling to me and to my parents. They couldn't believe it. So, and that has gone on throughout most of my life, including becoming a judge.
Well, and I want to go into that now for a moment.
Mm-hmm.
You have been a judge now, if my math is right, about 26 years.
That's right. Doesn't seem possible.
Give me your thoughts about the nature of being a judge as far as should judges be proactive in the courtroom? Are they proactive in your view as far as it relates to professionalism and ethics of lawyering?
Well, Paul, there obviously are no absolutes, so it's very difficult when you're talking about that, and my views are just that, my views.
I understand.
They're subjective evaluations based on my experiences. I don't think anyone is qualified to be a trial judge unless they've been a trial lawyer. That's just how I feel about it. Now, there are many, many exceptions. Some of the most wonderful trial judges I know were not trial lawyers. So there obviously are exceptions. But I think trial judges should have been trial lawyers, because I think trial judges need to understand the balance of letting the trial lawyers try the lawsuit, but at the same time making certain that they do it within the rules and properly, and to assist the jury, if it's a jury trial, in understanding what's going on, and to trying to make the whole thing flow easily. I love trying lawsuits, and I still try lawsuits. I still sit as a trial judge because I simply love the courtroom. But my approach is the trial lawyers know the case. So when you say proactive, trial judges ought to think a long, long time before they start asking questions, because the trial lawyers know the lawsuit. They know what's involved in the lawsuit. And I don't think a trial judge should try to influence where the case is going unless it's really necessary. Now, on the other hand, I do think there are methods. If jurors have questions, I think jurors ought to be told they can ask questions, but I think the trial judge ought to handle it very delicately. Number one, the trial judge ought to explain to the jury how it should be done, that it should be done in writing, that the question should then go through the judge. The judge should be given an opportunity to talk to the lawyers about those questions before they're put forward in open court in front of a witness. And so I think there are methods that can be used by trial judges, and again, these are my feelings, but I think the trial judge should try to allow the trial to go forward smoothly, as I say, in accordance with the rules. And I love doing that, and I think trial lawyers will do that. I used to try and still try to talk to the lawyers. What are the problems? Where are we going to get into difficulty? What do you anticipate? Let's talk about it ahead of time. Help me understand where you're going or what you're trying to do. Because I view trials, and if we could go back to the old English system, We took the adversary system from England, but it seems to me we've forgotten a little bit about what the adversary system is truly about. My view of the adversary system is each litigant has the right to present through an advocate the best version of their position. Now that's what it's about. Then the fact finder is going to resolve any disputes, assign weight to credibility, and decide what the probabilities are in a civil case or what the facts are beyond all reasonable doubt in the criminal context, recognizing the burden of proof. I don't think litigants have a right to expect lawyers to lie or to cheat or to not produce records. They only have a right to have an enthusiastic advocate put forward their best position. Then the conflict should be resolved in accordance with the law, depending upon what the facts are. That's all any litigant has a right to expect. And I think that's what we're about. And I try to discuss that with lawyers before a trial starts, and that's the approach I try to take to it.
Is there a code or a trial lawyer's code of civility that you implement or discuss with the attorneys before a trial commences?
I'm not so sure that we discuss it in specifics, but what I try to tell trial lawyers is, look, I want you to enjoy this experience. Practicing law ought to be fun. Not fun in the sense of going to a comedy or watching a play or a movie that's a comedy, but fun in the sense of doing what we're about and doing it to the very best of your ability. And it's not going to do any of us any good if you fuss with each other. If you've got a difference of opinion, present it to me and I'm going to rule on it. Give me your basis. Let me know what the grounds are for what you want to do. And let's approach it on that and discuss what the rules are, what the law is, and I'll give you a ruling. I do know that judges take different approaches, and they work very well. I know for years and years, Judge Jim Kehoe, who I think is a marvelous trial judge, had a very firm rule. Lawyers simply did not talk to each other while the trial was in process. They never directed a comment to each other. Any comment was directed to the witness or to the judge. Now, I never went that far, but I recognize why he was doing that. I never went that far because I never felt it was necessary. And I must tell you, I've never had a problem. I have never had a problem with lawyers being disrupted in the courtroom.
Well, this is something that we had discussed earlier on. Some people do say that some judges get the lawyers or the lawyering they deserve. What are your thoughts about a statement like that?
Well, I don't know, because obviously your personal experiences. We had wonderful trial judges when I was practicing law. It was really fun to try lawsuits. Some were much more difficult than others. There's no question, it was no secret. It was harder to try a lawsuit in front of Judge Choate than it was in front of Judge Van. Why, I'm not exactly sure, but the judges have personalities. But no, the practice of law ought to be fun. And as I say, it seems to me that if a trial judge has had some experience as a trial lawyer and understands the role of a trial judge and really wants to help the process move forward, and I think good trial judges want to do that, they're not concerned with the outcome. It's not that they don't care about the outcome. They just want it to be a fair trial. They want the process to work. And that's particularly true if you're talking about jury trials. And in a large sense, it's true on the Court of Appeals. I used to laugh with some of my brothers and sisters, and we still joke. One of my good friends on the Court of Appeals used to say, Pete, the problem with you is you still think like a trial judge. And I'd say, well, the only nicer thing you could have said was I still think like a trial lawyer. Because I think the process should be allowed to work. The process is truly majestic. And if we let it work the way it's supposed to work, we will come to the right result, to the correct result, most of the time. Not all the time, but most of the time.
Judge, let me ask you this then. If I were to give you a magic wand and say, here's a magic wand. You can use it any way you deem appropriate or necessary to make things in our profession better, in any area at all. What would you do?
Well, so that's even better than being the benevolent dictator.
Right.
I think I would establish some sort of an internship program, some sort of a mentoring program. We would find some way for lawyers to find the time to participate in programs like the American Inns of Court. We would then establish even more programs than we have now to train trial judges. We would select trial judges from the very best of our trial lawyers, and we would pay trial judges enough so that those lawyers would be able to do it financially, so that it would be an attractive position. On the courts of appeal, I would have a mix. I would have a mix of ample numbers of trial judges who had been trial lawyers and trial judges. We would mix in a few academicians and maybe some others from different backgrounds, maybe some very, very bright office lawyers who had been involved in different areas, such as intellectual property or corporate law, antitrust, dealing with governmental agencies, maybe government experience, would sort of try to get a mix or a balance of that. And on the Supreme Court, maybe the same sort of a mix, but 9 of the very brightest men and women that we could find in our profession with that background. And the magic wand might improve it to some extent.
Excellent.
But the system is designed beautifully. The system really does work.
That's what I was just going to say. In your view over your history, the system did work and does work.
Oh yes, it really does. It works so well, and we are so blessed to have it.
Judge, we've spent about a half hour or so.
Really?
Believe it or not. And is there anything that you would like to share with us? Any thoughts that you would like to share with us? A lot of people are going to be looking at this video that I haven't covered in these questions I've asked you.
Well, only one comes to mind, and that is, I really get upset and depressed when I hear young lawyers tell me how unhappy they are. And I think that is nothing short of being tragic. Because I can honestly tell you that I have been anxious to get to the office each and every day since I was sworn in as a lawyer. And it seems a great tragedy to me that the younger lawyers are not experiencing that today.
Why do you think that is?
I don't know. I think maybe some of it is built-in pressure. Maybe some of it is that we're not talking enough about how unique the profession is. Maybe we just need to get together more. You know, one of the greatest institutions we had in downtown Miami when I started practicing law was Benji's. Benji's was a coffee shop. The judges had motion calendars, and after the motion calendars, and they all ran for about an hour, from either 8:30 to 9:30 or 9 to 10, 99% of the lawyers that were involved in motion calendars went to Benji's for a cup of coffee. And you obviously mixed. You knew everybody. I'm sure there was more law business accomplished from 10 to 11 in Benji's than from 11 to 6 or 7 that night in law offices, because the lawyers talked about what they were doing. We talked about personalities. We talked about families. We became friends. We need a Benjis. Maybe we need 10 or 12 Benjis. We need for lawyers to get together more. We need for lawyers to talk to each other more. We need to become friends. The concept of the English Inns of Court is, and I asked one of the presidents of the Middle Temple once, I said, you know, what's the secret to your success? He said, Judge, it's very simple. People who break bread together don't lie to one another or deceive one another. Lawyers need to talk to lawyers. We used to have annual parties, and 90% of the lawyers would go. Well, you couldn't get 90% of the lawyers today in one room or one building. So we need to do something to create this atmosphere. We need to like each other. We need to get to know each other. Lawyers are wonderful people. Most lawyers are charming, delightful, fascinating people. They're bright as hell. They know a lot about a lot of things. They know a lot about philosophy. They know a lot about art. They know a lot about history. We've got to do something to strengthen this relationship with each other. We've got to get to know each other. If you know, we'd like it.
And so what you would tell the younger lawyers would be, hang in there and do what?
Get active in the bar. Go to the bar meetings. Go to anything you can go to. Find out who the lawyers are. If you go with a law firm, force yourself on the senior partners. Harass them. Spend time with them. Make them eat lunch with you. Spend all the time you can with them. If they like to fish, go fishing with them, even if you don't like to fish. Learn how to play tennis or golf if that's where you can spend time with other lawyers. Spend time doing things with other lawyers. Get involved in the law school activities. Support your law schools. But meet all the people you can. Get involved in the community. Lawyers are the leaders in our communities, and we're going to be the leaders in our communities because we've had the most blessings. We are bright. We are well educated. We understand how government is supposed to work. We ought to be involved in government. We ought to be involved in civic projects. They ought to do more and more of that. But above all, they've got to meet more lawyers, get involved in the legal profession in every way they can. And I think they'll enjoy it more.
Judge, this has been a joy for me. And I thank you for taking the time out of your busy schedule to spend time with us.
Paul, I thank you. I've enjoyed it. As I say, I don't know how I got on your list, and I can't believe we spent 30 minutes, but it was a pleasure.
Thank you very much, Judge.